हेलो एवरीवन एंड वेलकम बैक टू कॉमर्स वे। आज के वीडियो में हम लोग देखेंगे व्हाट इज मेंट बाय प्राइवेट प्लेसमेंट। सो बेसिकली दिस कॉन्सेप्ट is defined under section 42 of Companies Act 2013. So before going to this particular flowchart, let us go and see what does section 42 of Companies Act exactly say. So let's scroll up and see what is section 42 of Companies Act exactly saying. Section 42 talks about the term private placement. So what do you understand by private placement? A company has various options, or we can say it has various methods how it can raise its securities. The oldest and the most common method of raising share capital is through public issue. So in case of public issue, securities are being issued to general public, for which making of prospectus is compulsory. But when you go for a private placement, you don't have to make a prospectus. Instead of prospectus, companies will have to make an offer letter. They have to make an offer letter wherein the letter is addressed to a particular person. It is addressed to a particular person. So the company has already identified its investors and they send letters to those respective persons only. So the subsection 1 of section 42 says that a company may make private placement through issue of private placement offer letter. सबसे पहला सवाल उठता है कि कंपनी मतलब कौन सी कंपनी, प्राइवेट और पब्लिक? And the answer is both. A private company as well as a public company can go for private placement. Next subsection says that offer of securities shall be made to such number of persons not exceeding 50. So at a time, private placement offer letter can be issued to maximum 50 persons, and it excludes qualified institutional buyers and employees of the company. What is meant by qualified institutional buyer? That is given under explanation 2. The explanation of the subsection defines what is meant by qualified institutional buyer. So excluding QIBs and employees of the company, you can make a private placement offer letter to maximum 50 persons in a particular financial year. The number should not go beyond 50. Third subsection says that no fresh offer or invitation under this section shall be made unless the allotments with respect to any offer or invitation made earlier have been completed. So if you went for a private placement in the previous year, you have to make sure that you go for its allotment and only then go for a fresh issue of private placement. Subsection 4 says that any offer which is not in compliance with the provisions of this section shall be treated as a public offer. If any of these provisions are not followed, we cannot call it as private placement, and in that case, we will have to call it a public issue. We will have to call it a public issue of securities. Investors who are going to invest into the securities of the company through private placement shall pay the money through check or demand draft or any other banking channels, but not by cash. Cash is not entertained at all. It has to be in some other form wherein check, DD or other banking channels are said to be the accepted modes of payment. The next point, which is a very, very important point, talks about the days within which the allotment of securities must take place and what will happen if the allotment does not take place in the specified number of days. So to understand this particular subsection, let us go to the flowchart. What have we understood so far? When I say company, it means either a private company or a public company. So any company can go for private placement. If you're going for a private placement, the company should not go for any kind of advertisements. It should not go for any kind of advertisements on any social media or through newspapers or through any other ways, because it is a private placement. So you have already identified the investors, you have identified the persons who will be interested to purchase the securities of the company, and therefore you have to make a private placement offer letter and give that to those investors. Entire information relating to the private placement is to be filed with ROC within 30 days. Coming to our sixth subsection, private placement. After going for private placement, if the company is going to go for allotment, that is applications अगर accept हो जाते हैं, company is supposed to go for allotment of securities within a period of 60 days. If company goes for allotment within 60 days, then you have to move to the next step, that is filing return of allotment to ROC. You'll have to file return of allotment to ROC. But if the company does not go for allotment within 60 days, if it does not make allotment of securities within 60 days, then it shall repay the application money which it had received within 15 days. Ultimately, वो पैसे investors के हैं. So if you're not going for allotment, you should at least repay the application money within 15 days. If company repays it within 50 days, it's a good situation. It is a happy situation for both the investor as well as company. But if the company does not repay the money within 15 days, it is going to attract an interest at the rate of 12% per annum. So if company fails to repay the application money within 15 days, company will have to pay an interest of 12% per annum on that money. So this is what is being explained under subsection 6 of section number 42. So let's come back to the provision. Subsection 7. Subsection 7 क्या कहता है अभी देखते हैं. All offers under this section shall be made only to such persons whose names are recorded by the company. So basically, as we are talking about private placement, this subsection says that you will make an offer of securities only to those persons whose names you have already identified and noted. So it is made only to such persons whose names are recorded by the company prior to the invitation to subscribe, and that such persons shall receive the offer by name. So when we send them an offer letter, we are addressing it to that particular person because we already know the person who will be interested in investing into the securities of our company. So it is addressed to a particular person. Subsection 8 says, no company offering securities shall release, no company shall release any public advertisements or utilize any media, marketing or distribution channels to inform the public. Why? क्योंकि ये public issue नहीं है. This is private placement, therefore आपको public को inform करने की जरूरत ही नहीं है. Subsection 9 says, whenever a company makes any allotment of securities under this section, it has to file a return of allotment with the ROC. In this return of allotment, you have to state the full name of the security holder, his address, number of securities allotted to him, and all the other relevant information as may be prescribed. The last subsection of section 42 talks about penalty. This is talking about the penalty. So if any of the provisions mentioned above are not complied with, it is going to attract a penalty. The penalty may be amount involved in the offer or 2 crore rupees or whichever is higher. And the company shall also refund all money to the subscribers within a period of 30 days of the order. So after understanding the exact provision given under the Companies Act 2013, if you scroll down to this particular flowchart, you will understand entire section 42 in a summarized form. So just have a look at this particular flowchart. You can also note this flowchart, write it down. The last part that we discussed was the penalty for non-compliance of section 42. So the penalty provision is also mentioned over here. So that's it. That is all about private placement under Companies Act 2013. Please take 2 minutes and make sure that you note down this flowchart. It is covering all the 10 subsections given under section number 42.